Because if they come in late, it'll be difficult to walk through everyone. Oh, they can sit in the back.
Good evening to all of you. My name is Madhav Menon. I have been teaching law in several universities in India for the last 50 years. So a very senior teacher, so to say, and now retired and settled in my hometown, which is around 2,000 miles away from here, southern tip of India. In the Hindu mythology, there is a belief that one has to, at some stage in life, renounce your worldly connections and try to prepare yourself for salvation. And we call it sannyasa or vanaprastha. That is after your active life with acquiring material wealth and all that, there is a time in which you start off distributing this wealth and then pursue in the spiritual path, preparing yourself for salvation. So I am preparing myself to that last period of salvation now. So I was quite excited when several months ago Krishna Dev Rao and Martin Geer conceived this program of bringing you from United States law schools and bringing together some Indian students and have a program like this in which you will examine important legal issues from multicultural perspectives. Law may be the same thing, but the way one experience that, one interpret that, one perceive its impact in society might vary, and it is quite exciting. And you need to know that now more intimately because that we are said to be globalizing. So in a globalized world, one of the things which will get unified and integrated is the legal system. It has already started in the field of commerce and business, the emergence of WTO, the emergence of international monetary institutions. You find that increasing integration and along with that some sort of a unification of commercial law is really happening. I should think that eventually many other branches of law will find closer and closer similarities, and you will get perhaps accommodation and compromises which one has to make if one has to live with different cultures and different systems in a global village. Therefore, it was quite an exciting experiment. It's a unique experiment. I therefore want to congratulate Martin, Krishna Dev Rao and others who made it possible, and then welcome you on behalf of one of the senior law teachers of this country. Your stay here, I hope, will be pleasant, intellectually stimulating, and you will gather some aspects of the contemporary Indian scene. But you will not get it from Delhi. Delhi is not representative of India. So if you travel 2,000 miles towards the south, you will come across at least half a dozen different cultures, languages, religious groups, cultural practices, so much of diversity. Even food that you get at the airport or the railway station might be different. And if you want to experience that sort of diversity, you really have to travel, not by air, but by road or by rail, and stopping at different places. And then only I, having lived here for now almost 75 years, I haven't had experience of some of the extreme northeastern parts of India, where there are totally different cultures, even legal systems, which are more what we call tribal legal system, indigenous cultures, with different practices being followed, laws being different. So you have to live much longer and make a conscious effort if you really want to have a feel of the diversity that is India. India, as you know, have 29 states and about 6 union territories. Union territories are territorial units, some of them as big as a state, but they are administered by the union government, the federal government. But otherwise they are independent states, like states in America with their own legal arrangement systems, some of them participating with that of the federation. There are a lot of differences between the American Federation and the Indian Federation, some of which you will be discussing when you have some constitutional law sessions. But there are more similarities, because during the constitution making in India, the Indian constitution makers have visited America and interacted with some of the best minds in constitutional law in the United States. And some parts of the Indian constitution have been, if not in letter, but in spirit, borrowed from the American constitutional experience. Our constitution has an amalgam of the best of constitutional experience of different democracies around the world. So 28 states, not of the same size, not having equal representation in the federal government, unlike America. If America has 2 seats for every state in the Senate, we don't have. There are some states in India which has only 1 member in the upper house of Indian Parliament, whereas there are some other states which is as many as 50 members in the upper house of Parliament. And there is a lot of tug of war why this should be like that, when the upper house is supposed to be the Council of States. So some unresolved, interesting constitutional questions are now arising in public discourse and are being tested, whether we should amend the constitution giving equal rights in federal governance or the legislative body. Be that as it may, the population-wise also is vastly different. I come from a state in which the population is around 3.5 crores. You know what is a crore? It's about 10 million. 10 million. So about 35 million is the population. But there are states which has 350 million as the population. So you know at present, in terms of numbers, India has 1.2 billion people, 1/6 of the human race. Every 6th human being in planet Earth is an Indian. So therefore you are visiting a country which is democratic as much as America is, which is the most populous. Somewhat more is China, but China tells that by 2020 India will overtake China in terms of numbers. And you must also understand that this population is a young population. We have people below 35 years of old, 600 million people, almost double the population of America. Is of the age group below 35. That is why, people say India has a demographic advantage, in the sense that the productive workforce in our country is much larger than many European countries or America, where the population is growing old and older and older. So in many countries, the bulk of the population, 50-60% are 60 plus. And zero population growth in those countries. So much so, India expects to be a country, if it is economically developed, if poverty is eliminated, corruption is controlled, we would be a potential economic power to be reckoned with in the next few years' time? When America has 2% economic growth, in the recent times, India has 8 to 10% economic growth, consistently for the last 15, 16 years. So some of these things I am generally telling you in order to have a perspective of the country that you are in. And you may not be able to gather the dimensions of the strength and the weaknesses of this country by sitting in India or reading the Delhi newspapers. You will have to interact with people. I am glad some Indian students from different parts of the country are here who might give you some insights about peculiarities of their region, which you might like. They might take you to some of the films which are produced. We are one of the countries which produce the largest number of cinematographic films. And if you take all the vernacular films that are produced here, we are the single most large film producer in the world. So therefore, films convey a lot of Indian culture, and some of you might like to look into select films which are recommended by Rao and others. I have been asked to talk to you in the first day itself to give some general perspectives about 3 or 4 things. One, to talk to you about the Indian legal system, which includes the judicial system as well. 2, to talk to you about the Indian system of legal education. 3, to talk to you about human rights and its protection generally in the Indian legal system. And 4, international human rights and its development and Indian perspective. All these are subjects for detailed discussion in different sessions in your course as I see the program. But I am to give a sort of bird's eye view on some of these things which I hope will not be in a prepared text, which I didn't want to, nor a PowerPoint, but a general discussion. And I might put it in a provocative style so that you will raise some questions or comments on that. Sometimes I may exaggerate, so Krishnadev Rao and Prasad will intervene to moderate it. So therefore, it is going to be a discussion because it's a 2-hour session and no one would like to speak for 2 hours a lecture. So it is not a lecture, it's going to be a discussion. So to get into these 4 topics, and in between I will go into some extraneous things also to make the discussion lively and to keep you awake for the next 2 hours. Legal system. What do you include in a legal system? I am told that law is part of culture. So if you want to understand the law or the legal system of a country, you need to understand the culture of that country, which goes, in culture so many things are involved. The whole traditions, the civilization, the religion, the culture. I don't have the time to go into the diversity and how it got about, the history of its development and all that. But I would like to emphasize one point. Ordinarily, when you talk about a legal system to a group of lawyers or law students, we talk about 3 things which makes it a system. After all, what is a system? It's a functioning process for achieving certain ends. That end is justice. So what is the concept of justice in a given society? How it is organized and dispensed with is the issue when you are raising the question of a legal system. It has 3 legs, as I would put it. The first is the laws. What are the norms, the rules, the standards which make your system? Which is relatively easy to understand. So many laws with so many cultures and so many states involved, you will have multiplicity of laws. Nobody can tell you that I know the Indian law. It is ever changing. But nonetheless, we will see what are the main sources of that multiplicity of laws in this country. That is one leg to access a legal system. The second important thing is the institutions of law. If these norms and standards were to be executed, implemented, you need institutions. Executive, legislature, judiciary, police, prosecution, prisons, correctional services, civil services, governor, prime minister, cabinet, parliament, all are legally created institutional structures for applying or implementing the norms and standards which make the law, substantive and procedural law. So that is the second pillar of the legal system. And the third pillar, if you have the laws and the institutions, they do not get executed. To be able to execute, these institutions have to be manned by human beings, whom we call the personnel of the law. They may be the police, the prosecutors, the lawyers, the judges, whomsoever who are the implementers. So if you were to look into a legal system, you would fundamentally be looking for three important areas. One, the set of laws, substantive, procedural, including delegated rules, regulations, all that sort of thing. The second, the major institutions of those laws intended to implement these norms. And third, which is very crucial for us, is the personnel of the law. Because many of the drawbacks and inadequacies of the law and the institutional structures can be overcome to deliver justice if the personnel are equipped, competent, and trained. That's where the legal profession becomes important. That's where the judiciary becomes important. That's where the training of the personnel, the police, the prison officials, all those associated with the administration of justice become crucial. So therefore, in this broad perspective, I would say look at the law. We have about 6 or 7 sources of law in this country. Because of this multiplicity of cultures and the hold that religion has in Indian society, we have still customary laws being adopted and practiced. In fact, the whole area of what we call personal laws, marriage laws, marriage, divorce, separation, inheritance, succession, adoption, maintenance, custody, some of them are codified, but many others are still religion based. So, long ago I had an occasion when I was a visiting scholar in Columbia University Law School. I was asked by my professor there, would you go and give evidence on a dispute that was happening in British Columbia between the state and an immigrant, Indian immigrant, who went and married a Canadian there, who was a very rich fellow. Unfortunately, he died in the second year after marriage, leaving all this estate, which this lady naturally claimed, saying that I am his lawful wife and I married according to Hindu customs in Punjab. But Canadian government said, no, this is not a valid marriage, you are not his wife, and therefore the state can claim that property which was left by that citizen of Canada. I was asked to give evidence on behalf of this woman to say that without the two husband and wife being physically present, marriage can be solemnized in India as a customary marriage. Because the Canadian fellow never visited India. And he claims that this lady is married to him 2 years ago. So in Punjab, there was a custom whereby the lady could, with the photograph of the would-be husband, go around the fire 7 times and at the end of the times, the marriage is solemnized. I know Muslims marry through telephone. So therefore there are customs which are there, and there are so many widely varying customs of marriage, which are all valid, customary laws of marriage. So this whole area of marriage law, family law, you find for Christians the Christian marriage law, for Muslims the Muslim family law, for Hindus the Hindu family law is so diverse. And the same court will have to apply depending upon the religion of the litigant. Then the judge will have to look into that law and then interpret. And while looking into that, it's not codified, all that is not codified, he has to interpret customs. To prove customs, you have to have witnesses who would come and say, yes, it is an age-old custom, this practice still continues in that remote part of the country. And that is the evidence on the basis of which marriages are proved, dissolution of marriage is proved, inheritance is claimed, all that sort of thing. So therefore, customary law is still, it's increasingly getting codified, is part of Indian law. This will be very difficult to access for a foreigner. So we tell our students, look, when the trade in legal services happen, American lawyers come and set up law offices in Delhi. You don't have to fear, they will not be able to access all the family laws. They will not practice on family law. It's rather difficult, much of which will be based on the second important source, of course, is our constitution. Not second, it is the first one. Like any other country, that is the fundamental law. All laws stand or fall on the basis of the test of the constitution. So constitution and its interpretation. Constitutional law is not merely the text of the constitution written in 1950 when we adopted the constitution. In the last 62 years, so much of constitutional law has come about, partly through amendment by the parliament and partly by interpretation by the Supreme Court and the High Courts. So therefore, another source of law is this constitution and its interpretation. A third, of course, is the activity which our parliament and state assemblies are involved in. In every sitting, they pass another 10, 15 laws more. So this statutory law that are enacted, particularly by legislative assemblies and thereafter by the executive through delegated legislation, creates a whole lot of laws, which is the world in which the lawyers thrive here. The more the laws, the more the confusion, the more the legal practice. So we have any number of laws passed like that. The fourth is the common law, which we all share. America and India share from the British Commonwealth, from Britain. That common law, for example, the entire area of tort law in this country is British common law. It's not codified. So therefore you can cite an American case in an Indian court on a tort litigation in quantification of damages or on any other matter relating to tort litigation. That is why when the Bhopal gas disaster happened here, we preferred the litigation in America because the tort law is the same. And one of the claims that the Indian government made against Union Carbide in the American court was that the tort litigation in this country is not well developed, whereas in America it is well developed. So therefore we are litigating in America, the law being the same for both America and India. So tort law is common law, that is yet another source which you can say. And then lastly, we are now developing a part of our jurisprudence based on international law, both customary international law as well as treaty law. And treaty law has been increasing, as you know, in the recent times, which is, according to our Supreme Court, is accepted if it is not contrary to domestic law and a treaty has been agreed, signed and ratified by India. Courts in India is empowered to interpret that law as if it is part of domestic law. That's the reasoning. So therefore, international law, constitutional law, our own statutory law, customary law, English common law, these are all forming part of Indian laws. Huge ocean, which in a lifetime a lawyer will not be able to understand all its aspects. Any question or comment you would like to throw here, please?
I have a question about the family law. Can somebody choose not to have the religious law?
Yes, you can. It's a good question. You know, if somebody do not want to be bound by the religious law to which he or she belongs, it is possible. We have a secular law under which you can have, this is called a Special Marriage Act. You can marry and then determine how do you want to be governed by a contract. So similar things are possible in other aspects of family relations. Any other comment? What are the sources of American law? Would any American student volunteer? Of course, statute, the Congress passes all laws which are there. Your state legislatures pass. The judicial decisions of the Supreme Court, they are precedents, they are binding sources of law. Is there any other source?
The common law.
The common law, yes, it is there. It is to the extent that it doesn't conflict with the statutory law. You borrow the common law as well.
The international law, like you mentioned.
International law, subject to, that's a question which I suppose you will discuss later. How much of international law is part of domestic law of America?
Maybe the conventions of some of international.
Yes, whether it is convention, it will all go under the label treaty law. International law is two main branches. One is called treaty law, the other is called the customary international law. So conventions will go into treaty law. Any other source of American law?
Constitution.
Constitution and its interpretation, certainly that will be. So one main distinction is our customary law. I don't know whether custom is recognized. What about the indigenous people in the United States? If they have certain custom, where do they live? Alabama or Arizona? The indigenous Indians there?
Many different states.
If they have a customary practice there, will your courts recognize that?
They have their own court system.
They have their own court system. Which means, for some section of Americans called the American Indians, they have their own laws and their own court systems by which they are governed. That's part of American law. So therefore, custom still has some force, custom or practice which is recognized. If they contradict the American Constitution, can they practice it?
Yeah.
Can they?
They're separate sovereigns, my understanding. They have
Ah,
I don't know enough about the tribal law.
I suppose not. After all,
They're
they are
considered separate sovereigns, but they still have subject to the U.S. Constitution.
that's
But there's military law.
override. Yes, that's right. Yes, I will now briefly talk to you about some of the institutions of the law, of the legal. These are laws which are plenty like that. In institution, or let me start with some observations about the Constitution, because that is something which is very common between India and America. I had occasion to teach a course on equality and affirmative action in India and the United States. I did it in Washington University in St. Louis about 15 years ago. It was quite an interesting analysis of how America has been attempting to bring about equality to the African Americans and other groups, minorities in America, by using the 14th Amendment and the jurisprudence of affirmative action without resorting to quota or reservation as we do it here. Here we have adopted the extreme position whereby we said you cannot treat two people equal if they are in fact unequal in several respects. How can you treat a one-legged individual and an able-bodied individual equal? And you can say, well, you can join the Olympics and run. They cannot. So if I am asked to bring about equality among this disabled individual and the normal individual in sports, what do? I will ask this one-legged individual in a 100 meters race to be 50 meters ahead and ask the two-legged individual to stop at the 100 meter. Will that be equality? No?
It's not that equality.
Why is, then if you put that one-legged individual along with the two-legged individual at the beginning of the race, is it equality?
There should be separate games for the.
That was the case, that was the situation which was declared unconstitutional in Brown versus Board of Education. Equal but separate.
Differently disabled, they get a separate sport.
Any other opinion? How can you have equality
It is separate Olympics.
between a disabled and he says, no, they cannot be equal with able-bodied, they are equal among their equals. That means equality among.
There is a separate Olympics.
But Constitution doesn't say like that. The Constitution says all American citizens are born equal and equality will have to be guaranteed. So therefore you have a problem, which of course you will be discussing. Is affirmative action, I mean, you have number of affirmative action programs. The jurisprudence by itself, it's an amazing issue in constitutional law for which no country has found an appropriate solution. It is, can man and woman be equal?
No, but for the fundamental right itself.
How can a fundamental right be equally given? Because you will have a number of issues in which you want equality in every aspect. Fundamental right or whatever in every aspect. But by biological or other reasons, God has not created man and woman equally. So therefore, our concept of equality is not certainly absolute equality. It's an equality in a relative sense. It is an equality of opportunity. It's equality of status. It's equality by non-discrimination. That's all. Which means there can be fair discrimination. The constitutional concept of equality only disallows unfair discrimination. That means you have a whole jurisprudence of what is fair and what is unfair. To be able to decide as to what is the equality that the Constitution is talking about. And if you look into that, you will have to go into sociology, you will have to go into psychology, a whole lot of knowledge about human beings and their behavior, their mental makeup, their genome. Quite exciting. Today, the people who are doing genome research, geneticists, they are saying, no, they can bring about absolute equality by identifying those genomes which give us certain capabilities. But if you attempt to do that, what will be the society, what will be the law is a different matter. But let me tell you that there are in Constitution of America and India some broad